its staff, management, or sponsors.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Hey, good evening. Welcome to another Ask the Expert show. We're with you every Thursday night from 6 to 7 during your drive time. And we bring on some of South Florida's finest attorneys, doctors, financial people. This is the first Thursday of the month, so that means our community association law show. And we could not have gotten a better firm than K. Bender Rimbaum. So I want to welcome board-certified attorney Robert K. And I have to add something, Mr. K. We get inundated by phone calls. We get letters that I have never seen the amount of, communications we get on this show. So we are adding another hour at the end of the month. So we'll have the first hour of the month, the first Thursday of the month, and the last Thursday of the month. So we are excited about it. If you'd like to give us a call here, the number is 888-565-1470. Let's welcome our expert, our longtime expert, attorney Robert K.
Good evening. Hello, Steve. Hello, everybody out there. Looking forward to lots of good questions today.
Oh, my God. We have been inundated. But, like we always do, because it's like I get letters from people going, they found the show by mistake. They were in their car going through the dial, and they found our show, and they couldn't stop listening to it. So tell everybody about K. Bender Rimbaum.
Well, K. Bender Rimbaum is a law firm that concentrates in the area of community association law out of our offices in Pompano Beach, Palm Beach Gardens, and Tampa. We have a large number of board-certified specialists in the field. I think of our 20-plus lawyers, more than half of them are board-certified in community association law. So we bring to our representation a lot of expertise, a lot of years of experience. K. Bender Rimbaum's been providing the services for over 30 years continuously in South Florida and expanded through other parts of Florida as we do it. Every aspect of what a community association deals with on a daily basis and their legal needs, collection of assessments, interpreting documents, contract negotiation, covenant enforcement, litigation with contract defaults, anything you can think of that your association deals with, we are providing those types of legal services.
I got to tell you, what is so great about your law firm is your firm gives back to the community, and you do it by having a show like this every month, and you also have your classes that you offer. And
right.
you're always educating people, and you don't get paid to do that. So
no, we don't.
What you do is you give back, and I think it's so wonderful because you're one of the very few law firms that do that. And most of your practice surrounds community association law. So
more than 90%.
That's good. So let's go. We've got already our first caller who's been holding for a while. Let's go to Harry in Miami. Good evening, Harry.
Hi, Robert. Hi, Steve-O. How are you?
Good, Harry.
Our property manager today sent out an email with new rules for pets, basically dogs. They were not adopted by the board. There was no noticed meeting. Our declaration gives the board the authority to adopt rules. But what are these rules if they're not adopted at a properly noticed meeting?
Well, if they're not adopted at a proper meeting of the board or by a written resolution signed by 100% of the board, then they would be suggestions as opposed to anything else.
Okay. And they also did it for our COVID rules. I think their tendency is not to want to issue board approved guidelines or protocols or rules, and they want the property manager to send it out. But never under neither of those situations, the COVID rules or these new pet rules were done pursuant to a duly noticed board meeting.
Well, there is a situation that Florida law does allow if the board is unanimous in the issue that it's addressing, such as adopting a rule regarding dog handling on the property, they can adopt a rule by a written resolution without holding a meeting if 100% of the board members sign on that resolution. It has to be unanimous, and then they have to give notice to everybody. Well, they've given notice, so you want to investigate how this came about, whether there is a resolution in your records that all the board members have signed. Without that, then they would have had to have called the properly noticed meeting of the board and allowed owners to be in attendance and to participate before they could adopt the rule.
Okay, one more question. If they do let's say, unanimous consent and all the board members sign it, does that have to be to protect the health, welfare, and safety of the residents, or does it have to be for an emergency, or can it be for any type of rule?
Anything that the board has the power to do, they can do that way. Now, it's not recommended that they do all the business that way because that's not the intent of the statute. It's not politically what you would want to see, but the law in Florida does allow it.
Even without a board meeting, even without a subsequent board meeting ratifying that?
Correct. The resolution acts as the action taken by the board as if it were at a meeting.
Can they ratify it after they take the action, or does it have to be done? Does their unanimous consent or their written resolution have to be done before they announce the new rule?
The unanimous consent resolution that they take doesn't have to be ratified. It can be ratified. They always can ratify anything that they've done, but there's no legal requirement that they ratify it. It's an official act. The resolution should be attached to the minutes as anything else that they have in the official records of the association. So it's not something that would be kept secret from you. And then the rules would become effective once they sent notice to everybody. So that's the missing piece.
Thank you very much.
Of your situation. Good luck.
Great. Thank you very much. Appreciate it.
Thank you. If you've got a question about your HOA or condo association, we have attorney with us, Robert K. of K. Bender Rimbaum. You can reach us at 888-565-1470. It's almost time to go to our first break. Do you want to go over what you've got coming up?
Sure. Well, in the month of May, we have 4 items for consideration besides the 2 radio shows that we've got with you. On Thursday, May 12th, we have a Zoom program at 11 o'clock to 12 noon, Conflicts of Interest, What You Need to Know, instructed by Allison Hertz out of our Palm Beach Gardens office. There is continuing education credits for that. It's May the 12th at 11 a.m. to 12. And then on May the 18th, Wednesday, from noon to 1 o'clock, a panel Zoom meeting, which Michael Bender will be participating in. The topic's managing your property before and after a hurricane. So as we're coming into that joyous season we have in Florida, many issues will be discussed. Mike will be part of a panel which will have other professionals in security, construction, claims, roofing, and banking. We'll be talking about that from 12 to 1 o'clock on Wednesday, May 18th. On Thursday, May 19th, there is a lunch and learn question and answer, like a town hall Ask the Attorneys with Sean Brown from our Tampa office, 11:30 to 12:45, also via Zoom. And also on Thursday, May the 19th, 5:30 to 7:30 p.m. condominium board member certification by Zoom with Emily Gannon from our Pompano office. That there's also continuing education credits for that. So that's what we've got upcoming in May.
What a busy month. Wow.
Yes, sir.
We're going to go to break. Robert, give everybody the phone number and your website address.
You can reach us at 800-974-0680 or kbrlegal.com. You can email at info@kbr.com. Go to the website. There's a contact block that you can fill out on the first page that would get to us and somebody would get back to you.
So if you're a board member or you're a property manager or you're a resident and you'd like to ask Robert a question, give us a call here at 888-565-1470. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we're back. This is the Ask the Expert show. We're with you every Thursday from 6 to 7 during your drive time with South Florida's finest experts in the field of legal, health, financial, and home improvement. This is the first Thursday of the month. We always have for the full hour. The K, it should be called the K. Rembaum show, because we left out Bender, K. Bender Rembaum, because we do it the whole hour. We've been doing it for almost 5 years now, and it is the greatest show of all of our shows we do.
Thank you.
What we also do, and by the way, we want to thank you for all the emails that people take the time to write us. You can write us, and it's also on our Facebook, but you can write us at Steven, STEVEN, at AskTheExpertsRadioShow.com. We got so many questions this week. If you'd like to call in right now, you can call us at 888-565-1470. And we're going to go to our first email, Robert. It's from Gene in Boca. So I think we're finally getting everybody to tell us if they're an HOA or a condo, because when we first started doing this, you didn't know if it was HOA, and there is a difference. So
There is.
almost every email we get now, they all tell us now whether they're HOA or condo. Anyway, they're redoing their tile roof for 170 units. Again, this is HOA. Work was completed. I was assessed $150 a month. I've asked the directors for specific breakdown with my accounting ledger. I have not received anything. What can I do? Shouldn't they have given me 14 days prior notice in the beginning on what the project would cost? Because we never got that either.
Well, if they're going to be adopting a special assessment, then they were required to provide advance notice of that, and then the board would do it at an open board meeting with owners in attendance and participating. And as with the last caller, the same could hold true on a special assessment. The board, by a written resolution signed by 100% of the board, conceivably could do that. It's not a recommended approach politically, but legally they are allowed to do that. So if this writer wants specific information, he would need to put in a written request to make an appointment to come in and inspect the official records of the association and review his account and any minutes or information that would be supportive of this special assessment. If there was no proper procedure followed, then the assessment is not technically collectible by the association, and the board would need to do something to fix that. You may want to put the board on written notice that this is an issue of concern. It may be necessary to bring in an attorney from outside to address it with the board, as sometimes the board is less responsive to the individual unit owners that are making inquiry, and might take an outside attorney a little more seriously on that.
You know, we used to get on this show so many people with pet questions. But we don't get that many anymore, but we did get one from Larry at Lighthouse Point. He says, is it true if a dog urinates on a common property, can the association have my animal removed? What if it's a service dog?
Well, urination on common property is not an unusual thing for a dog to do. In order for that to be an issue that could result in the required removal of the animal, there'd have to be something in the recorded covenants. This is not something that I think a rule would be sufficient on. I think you'd need something in the recorded covenants to have such a restriction and the enforcement aspect of it there. Putting it in a rule, I don't know that any court would find that to be a reasonable restriction on animals. Now, and it doesn't, if there's restrictions, service animals and pets still have to comply with restrictions that are properly adopted and reasonable in their application. So I don't think the distinction between a pet and an emotional support animal in this instance would be any different. But it sounds pretty extreme that in this community, if the dog urinates in the common areas, they would remove it. Now, if they're referring to, say, a clubhouse inside, well, that's another story. But if we're talking outside on the grass, that would be the situation that I don't think that would be entirely enforceable. So the details on that are going to be important as well.
Okay. We have several lines open at 888-565-1470. If you have a question for attorney Robert Kay, his law firm is Kay Bender Rimbaum. You know, I didn't say this, but they're in Pompano, they're in Palm Beach, and they have an office now in Tampa.
Tampa, yes.
So,
a couple years already.
Yes. Here's one from Judy in Delray Beach. Can management demand we use a certain accountant? It doesn't seem right.
Well, that will depend on the contract that the association has with the management company. Generally speaking, the contracts provide for the management company to recommend, but they can't dictate, and it's up to the board who they want to do business with. But it's conceivable that a management company can put into their contract that they will select the certain professionals that the association works with, And in that instance, the board has agreed to it and in essence delegated its entitlement to choose this particular vendor to its management representative. So you'd want to check your management contract to see if that's provided for. If not, then the answer would be no.
Okay. What about, we get so many questions, Robert, about Zooming. Can associations only have Zoom meetings and nothing in person? That was from Pepper in Davie.
Well, I think that's happening in a lot of situations. And to my knowledge, as of this point, there hasn't been any determinations from the courts whether that's something that is allowable on a regular basis. So associations are authorized to hold their meetings in a remote fashion, such as this. And obviously, the situation with the COVID is what spawned the larger use of that type of a meeting from what we experienced prior to that. And there is provisions within the statute that allow for it, and the board can make that determination. Annual meetings are a little trickier, particularly in condominiums, and it is recommended that there be a place in person where people can come when you're talking about annual meetings in condominiums in particular. And that's a more highly legislative and regulated type of ownership, so that people can physically deliver their ballots and observe the counting of the election materials. So it is recommended for condominiums that they have a physical place as well as just Zoom. Now, board meetings, I believe that pretty much Zoom meetings are happening in a lot of places, and there hasn't been anything in either the law or court decisions or even arbitration decisions with the division that has indicated that they can't do that. So as of right now, I think that's acceptable.
Robert, this will lead into our next question. What does the enforcement committee do?
Well, the enforcement committee can do a number of different things depending on how it's structured, but I think you're thinking in terms more of a finding committee. And different communities use enforcement committees for different things. Like in some instances, they have a committee that goes out and identifies enforcements and brings it back to the board, and then the board decides what they're going to do about it enforcement-wise. Finding committee may be the enforcement committee, if that's what they call it, but sometimes it's just called the finding committee. In order to legally impose a fine against individuals for infractions, there has to be a separate committee in place that will hold a hearing, like an internal mini trial, as to whether or not the fine that the board is proposing is going to be approved or not. So that the way that process works is the board identifies what violation exists in the community, and we'll send a letter out to the owner saying you're in violation, you've been fined X amount. It could be $100 per day, up to $1,000 in some instances. If in a homeowner association, documents can allow for more. In a condo, it can't be an assessment or a lien against the unit, but in the homeowner association setting, if the documents allow for it and it's more than $1,000, then it could be an assessment and a lien. But in any event, before that becomes effective against the owner, they have to provide for a date not less than 14 days from the notice at which the hearing before the finding committee will take place, at which point both sides present their position and the finding committee decides yes or no as to the fine. The committee is not supposed to negotiate or reduce the fine or do anything other than just rule yes or no based upon the materials presented by both sides. So that's the basic filing process.
Robert, is it true that at least there has to be at least 3 members?
at least 3 members, and they're not supposed to be board members, not supposed to be family members of board members or employees of the association or any way affiliated. They need to be separate unit owners.
Because Mark in
Don't
Boynton,
necessarily have to be.
he lives in an HOA, and he wanted to know if the committee, by being on this enforcement committee, does that make them an employee? But it doesn't.
Well, that question is more a basic, any committee. It wouldn't necessarily be enforcement committee, but they're not an employee of the association, but they do fall under the umbrella of the association's director and officer errors and omissions insurance policy. So there is protection for that, and there may be some other types of insurance, but where you have individuals besides board members involved, it's important to get with your insurance agent to make sure you have other types of protection, similar to like a workers' comp type protection, where if a committee member is doing something on the premises and is injured, that there's insurance coverage for that specific to like an employee, but somewhat different. So that's an issue to get with your own insurance agent on to make sure you have the right coverage.
If you'd like to call in, you have a question for Robert, the number here is 888-565-1470. Milton from Dania Beach. He lives in a condo. They said they're changing the style of the doors and windows, and we get questions like this all the time when it comes to material alterations. Is that considered a material alteration, and doesn't the vote have to be done first?
Well, by using the phrase changing the doors and the windows, then we're going to have to assume that they're not going to be in any way in appearance-wise what they were before. So if that's the case, that would likely fall within what is defined as a material alteration. The issue gets a little more involved. The statute provides that no material alteration or substantial improvement can happen to the common elements unless as provided in the governing documents. And if the governing documents are silent on the issue, then upon the approval of 75% of the owners. So the first thing that you have to do on this analysis is look at your documents to see whether there is a requirement of an owner vote, whether alterations are even allowed, because sometimes there's no allowing them. So you've got to determine it. Sometimes the alteration is based on a benchmark dollar figure. Sometimes it's a percentage of the budget. There's a number of different things to look for to see whether or not it's going to require a vote. And the other point that has to be kept in mind is whether or not the change is going to be necessary maintenance of the item as opposed to a cosmetic change. If it's a necessary maintenance, there's case law that has interpreted this to be an exception to the requirement of an owner vote, even if the documents require it, both as to the alteration and to the requirement of the special assessment to pay for it. So there is a lot to look at before you can say one way or the other. Now, assuming the documents in this questioner's community do require an owner vote for material alterations, and there is no dollar requirement to be a benchmark, and there's a specific percentage set forth, then yes, that's supposed to happen before the alteration is undertaken. And if they didn't, then that could be a problem, and an owner might go to the Division of Condominiums and see what type of assistance they can offer on that.
We're going to go to our second break. Robert, give us your phone number and your website address.
Cape Bender Rembam can be reached at 800-974-0680 for all 3 offices. You can write to us at info@kbrlegal.com or go to our website, kbrlegal.com, and fill out the contact information will get to you there. Also, you'll find there on the calendar the events that we talked about earlier that are upcoming, where you can register and make sure that you get the access to the Zoom. I did not mention that earlier.
Okay, we're going to go to break. When we come back, we got more with Michael. And not Michael, we have not Michael today. I just started thinking about Michael might be with us at the end of the month, but we have Robert K. And you're going to have to probably twist his arm on this. I know you are. But you know what? I know Jeff would love to do the show at the end of the month. Anyway, we're going to go to break. When we come back, it's the K. Bender Rimbaum Law Firm Association Law. We'll be right back.
K. Bender Rembam is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembam attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembam is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we're back. This is Ask the Expert show. We're with you every Thursday from 6 to 7 p.m. during drive time. And this is the first Thursday of the month. So that means for the full hour, we have Community Association law firm K. Bender Rimbaum, and we've had for the last 4 or 5 years now, we've had board certified Robert K. with us. And God, listeners love you. I mean, I'm not trying to butter you up or anything, but we get so many letters from people saying they love how you explain things. And that's what you get when you retain a firm like K. Bender Rimbaum. I mean, this
Not
show.
like,
What's that?
not like K. Bender Rembam, K. Bender Rembam.
So, we always, this show is educational. We don't ever want to make it sound like a commercial, but we really are. We're so lucky to have Robert K. with us. And again, they have offices in Pompano, Palm Beach, and in Tampa. That's their new office. If you got a question for Robert, give us a call here at 888-565-1470. It's 888-565-1470. We're going to go back to our questions that we get in, and it was amazing. We got in probably about 60 questions. I try to call them down for Robert, and we still have a lot of questions even after he went through them. So, and we really do try to get to everybody's questions. Our next question is from Sean in West Palm Beach. He wants to know if it's legal for an HOA board to fine a resident without finding a fining committee or due process because they agree to the fine. It was executed in a contract releasing the same resident from a violation.
Well, it's a complicated question that has been presented. We discussed before the break what the procedure is for fining, and it sounds like in this instance that didn't happen. But while they may call it a fine in the agreement of settlement that they've reached, that would be more of just a settlement payment that they've come to terms on the dispute that they had, and the owner agrees to pay so much money and not do the violation anymore, and the association agrees to stop pursuing enforcement. So that's more of a contract than it is a true fine, and there isn't an issue with whether or not that's legal or not. I think that's legally fine.
You know, a lot of people are now becoming renters for the first time in their life. And I got to tell you, we get so many questions now in regards to renters. Here's Phyllis and Davy. How come renters have no rights when it comes to attending board meetings?
Well, the rights relative to board meetings come from the statutes. So the legislature for the state of Florida decided who's going to have an entitlement to attend a board meeting, and they decided that would be unit owner. Renters, not being unit owners, do not have a right to attend a board meeting. Now, that doesn't mean a board can't allow them to attend or invite them to attend. They just aren't forced to let them attend as they are with owners. So renters don't have the same rights that an owner does. One of the ways that they teach in law school to think about property rights is you have a bundle of sticks in your hand, and that's all of the rights that you have in the property. So if you're a renter, some of these sticks get taken out, so you don't have the same number of sticks that you would have as if you were the owner, but you still have a lot of sticks and a lot of rights and things you can do as a tenant, just not all of them.
So you're saying renters do still have certain rights?
Well, they have rights to use the property. They have a right to use the common facilities to the exclusion of the unit owner, unless they invite the unit owner to come as their guest.
We have Benny in Hollywood. And by the way, before we go, let's go to Bernadette first in West Palm Beach. Good evening, Bernadette.
Good evening. Thanks for taking my call. The question is quick. I hope the answer is something you guys can give me. Marijuana smoke in a condominium, marijuana smoking in a unit, does the law permit that?
Well, the law does permit marijuana smoking in the privacy of one's own home. If the community has...
What happens when it permeates other units around?
Well, there's a host of competing interests that are working in this. In order to legally smoke marijuana, it's got to be medical, and therefore there's a prescription involved, and fair housing issues come into play as to the rights of the person with a physical handicap that gives them the right to do this. The fact that the smell might permeate into other units, that you may have owners that find that problematic, or may have some allergies that this might affect. And so then you've got whether their rights are superior to the rights of the person. And fair housing tends to fall in favor of the handicapped individual. And if you have competing handicaps, then it becomes more of a first-in-time situation. So under the circumstances, there's a lot of facts that go into it and how that can work. The marijuana laws currently don't allow for the use of it in public. So doing it out on a patio or on a balcony could be a violation of that, although within a private community, that's a question that hasn't been answered. I don't believe there's been any reported court decisions on this topic as of yet, so we're kind of in the wilderness.
Okay. So, and again, don't know if you know this, I thought if you had medical marijuana to smoke, that you couldn't smell it, but obviously I may be wrong.
Well, I'm not an expert on that, but there are different types. There's the vaporized pens versus, but they also have the regular flowers, and those smell like they always did. So that
Okay,
can be
I appreciate so much. Thank you.
Thanks, Bernadette. You know, it's funny.
Listen.
We got probably 10 emails about marijuana, about if it's okay to smoke, or I bet you what she's had is somebody smoking close by and she can smell it, and she wants to know.
We've seen it come up where it's in the hallways and people are complaining about it, or in the adjoining unit, upstairs, downstairs. I mean, when you're living in close quarters, and the way a lot of this construction is, certain smells do permeate into other areas, and that can create problems.
If you have a question for Robert, our phone number here is 888-565-1470. We're still here with you for the next 15 minutes. Here's another email we got from Kip in Fort Lauderdale. For an HOA, does the fining committee have to be appointed before the violation, since picking them after the fine seems unfair?
There's nothing in the law that requires the fining committee to be in place prior to the notice that there's a violation in existence and getting ready to have the hearing. It's not atypical for the board to appoint the committee when needed. And it changes, and it's not like a standing committee that's always there. So that's not something that the law has considered inappropriate.
This is from Ken in Delray Beach. He wants to know, he said, we have an association board and a rec board using the same property manager. Our rec board broke off and hired a separate property manager. Is this legal?
Well, that's a contract issue more than anything else. And if the contract with the management company and the two entities, the rec board and the homeowner association board, required them to stay together and didn't allow one to terminate without the other, that's a civil issue between the parties. It's not something that would fall under not being legal or criminal or anything like that. So it's something that would depend on the contract, and in all likelihood, there would be no issue with one of the parties breaking off. We see that happen quite often.
We're going to go to a break if you'd like. We still have about 10 minutes left. If you have a question for Robert, you can reach us right now. We have lines open at 888-565-1470. Robert, give everybody the phone number at the office.
You can reach us 800-974-0680, info@kbrlegal.com, or go to the website kbrlegal.com.
The greatest, I guess, community association website I have ever seen, and I have seen a lot of them. There is so much great information on there. You could spend literally hours on there. We're going to go to break. When we come back, we've got more with Robert K. K. Bender Rimbaum.
K. Bender Rembam is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembam attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembam is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembam today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back now with more of the Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law LLC, covering South Florida.
And we're back. This is the last quarter of our show. We're on with you every Thursday, but the first Thursday of the month is our Community Association Law Show. And now, starting this month, we're the last Thursday, we'll do another hour show because this is without a doubt the most popular show. And I got to tell you, Robert, we get so many letters from listeners saying how much they love the show. And that's what it's about. And we get board members, we get property managers, we get residents, we get all kind. And this is kind of like the show that you do that I love, that you do so well, you and Michael, where you answer questions. And usually, like when I was there, it lasted for 2 hours that people come in.
Oh, yeah.
That is the greatest. And that's kind of what the show is. It's just we're on radio.
We're hoping one day we'll be able to get out there and do live shows again with our town hall meetings. Hopefully things will get us back there this coming season. We got our fingers crossed.
Oh yeah, because I really noticed a lot was people would come in with a question, and they'd kind of fold up the paper after they asked the question, and 30 minutes they're asking 4 more questions because things come to their mind, and it's really wow. We had about 50 or 60 people there when I was there.
Each other in those settings, they'll have similar experiences. Some will have experiences that are going to help the people that are asking the questions. So it's a fun situation whenever we do it.
Here's a question. It's from Seth in West Palm Beach. Who does attorney work for, the unit owners or the board?
Well, that's a question that comes up quite often, and the answer is actually neither. The attorney works for the corporation that is the association, and while it seems like the attorney's working for the board, it's because the association operates through its board. The board runs the association, the corporation, and then the officers are the ones who have the day-to-day operational requirements to pass along information to the attorneys and give instructions. So if I had to choose for that narrow question, we're working for the board in appearance, but our client is the corporation that is the association. We don't have a special allegiance to the individual board members. Board members change periodically. Sometimes a new board has issues with the old board, and then it becomes legal issues with them, and we continue to provide representation in those settings as well for the association.
Robert, we got several emails. Here's one from Shelley from West Palm Beach, who's in a condo, and we got probably 3 of them that are similar to this. It says, what if we blew the deadline regarding year-end financial reports?
Did you say Shelley is a condo or an HOA?
Condo.
Okay. Well, condos blowing a deadline for financial reports can result in a fine from the Division of Condominiums on the enforcement side as a violation, whether it's probably a minor violation, but still it's a monetary fine based on the number of units. And depending on the level of the violation would be the amount of the fine. The division has gone through the years of different philosophies. Sometimes they offer opportunities to make a mistake and not suffer a fine. more recently, they've been imposing fines for first violations. So it's important to stay on top of these things. Now, sometimes financial reports aren't necessarily in the control of the board. They give them to their accountants, and then they have to wait for the accountant to finish it. And if the accountant needs more information, that could cause delays. And the statutes aren't written as clearly as you would want to cover all these different contingencies. It seems more black and white than it really is. So we encourage our clients to get their financial reports taken care of in a timely fashion, and that they be made available as they should be, either directly by mail or something that says they're available to anyone who requests a copy.
We just had somebody just text us just now wanting to know is it true that no more than 15% of the units can be rentals?
Well, it's not a law requirement. There are factors at play. Now, some communities will amend their documents to provide such a limitation, and in that community, that would be the case. It's one of the things that is looked at in the mortgage industry, Fannie Mae, Freddie Mac, and their guidelines for being able to get financing within the community. What level of percentage of units are being rented at any given time? It's usually over 20%, up to 25% before it becomes a problem in that area. The 15% is not a benchmark anywhere that I'm aware of, other than within specific communities that have amended their documents to so limit.
You know, Robert, we get so many questions about parking and not having enough spaces, to not having enough for visitors, for guests. We also about handicap parking. We got something from Manny in Coral Springs said we have a parking problem. We need extra parking for visitors. What do we do?
Well, it really depends on the physical makeup of the community. If there's room to create parking that doesn't currently exist, there's procedures that can be followed. You'd have to get a vote of the owners to go out through the common elements to provide for it. Then you'd have to go to the city or county, depending where you're located, to get revisions to your approved site plan to change the configuration of the parking and add the parking. And there's a few hoops you have to go through in order to extend your parking. But a lot of places, particularly more on the east side of the areas that we are in, the amount of land is very limited, and there's no place to put any additional parking. And those people, like a lot of those places, were developed with the contemplating maybe one car per person and very few guests, if any guest spaces, and that's become problematic for them. A lot of those boards will look for other sources of possible parking in the area that they can possibly rent or get some kind of a plan worked out for that. But it is a difficult one that there is often not a very good answer to.
Well, we've come to another end of the show. Always goes by so fast. Give everybody your phone number, Robert.
K-Bender Runline can be reached at 800-974-0680. You can reach us at info@kbrlegal.com. Or just go to kbrlegal.com on the website and look around, and there's contact me if you want us to reach you, or just go to our resources tab and look up the articles that we've got posted there, and have a good time.
We so appreciate you. We'll see somebody from K-Bender Rimbaum in about 3 weeks. Thank you so much. And we'll see you all next week with more Ask the Experts. Have a good weekend.
Bye-bye.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed